All right, I sent it over, Tracy.
All right, just waiting on it to come through. Okay, I have it posted. Let me just verify that it's working. Okay, y'all are good to go.
Okay, great. Good morning, everybody. Welcome. A meeting of the Louisiana State Board of Medical Examiners Occupational Therapy Advisory Committee pursuant to lawful notice is duly convened and called to order at 10:03 a.m. on Friday, September 12th, 2025 by Zoom virtual video. Please note any comments by the public are welcome and can be emailed to publiccomment@lsbme.la.gov. Jacinta, please confirm that you have verified the identity of all tele and video conference participants.
Ms. Jacinta is not with us today. She is vacationing in the north of Italy, so we won't be bothering her. And
All right, how about you, Dr. Van?
Miss Melissa's with us, and the only one I can't assign a name to is Miss whoever's KK iPhone 13, and we'll assign a name for the record.
Kathleen, that's you, right? Kathleen Norcross?
Yes. Yes. Yes.
Okay, great.
Okay, we'll fix that while y'all move on.
All right. Is the sound clear and audible to the public and those on the tele and video conference?
Yes, IT confirmed that.
Okay. All additions to the executive or public agenda must be made presently, as we will no longer make additions to the agenda after the close of the public session. I'm now going to review the mission. The mission of the Occupational Therapy Advisory Committee is ultimately to protect the public, i.e. the consumers of occupational therapy, by regulating competent practice and upholding the standards set forth by the governing rules and regulations. Members present are as follows: Kathleen Norcross, Kelly Brandon, Carolyn Murphy, Mary Green Keys, Raylena Crooks, Glenn Wallace, Amy Lariviere, and Ingrid Frank, who is the chair. Let's see. So members absent are Kim Solari, just Kim Solari. Glenn, can you confirm that we have a quorum?
We do.
All right, thank you. Also present at the meeting are Dr. Vincent Collada, Executive Director of LSBME, Patricia Wilton, Executive Counsel, Lauren Suddeth, LSBME Attorney,
Phyllis Johnson,
Phyllis Johnson.
Yes,
licensed analyst supervisor, and Angela Boudreaux, licensing analyst.
That was the only person I was going to ask. Angela Boudreaux is licensing analyst. Okay, great. I'll write that down. Thank you. Welcome, Angela. All right, I think that was everybody. So Susie Allen is not on today. Melissa Genders, is Melissa on?
Yes, she is.
Okay,
I'm here.
great. Jacinta's not. Tracy Morrow, is Tracy on?
Yes.
I am.
Okay, great. All right. All right, I think that's everybody. Well, let me share the screen with the agenda, and give me a second. It always takes me a minute to sort of really figure that out. No, that's not. I have it pulled up, but naturally, I think it's on this tab. Nope, it's the wrong thing. Where's my? Okay. Do you all see the cloud meeting agenda? Is that what y'all are seeing?
Yes.
Okay, great. All right, first thing we'll do is look at the minutes from our last meeting in July and approve those. So in July, we reviewed the minutes and approved them from the previous meeting. We talked about the LSBME tracking document. We went over the guidelines that the draft guidelines that AOTA created for re-entry into the profession for people who've not been in it for 2 years or more. We got an update about the advisory opinion on telehealth. We answered a question about dry needling. We talked again about like how OTAC can get practitioner questions to us. We went over what are the rules for reinstatement, and that was deferred to that will be that Phyllis would be working with Dr. Van on that. We went through the OTAC applications that we had at the time, and then decided that we needed to have a separate meeting to vote on them. So we created an August meeting to vote on them. And we had an executive session. So can I get a motion to accept the meeting minutes from July?
I'll make a motion to accept them.
All right, Carolyn, thank you. And second?
This is Amy. I'll second it.
All right, any public, I'm supposed to ask for public comment. Any public comment?
1 second, I'll check. And no, there are no public comments.
Okay. All in favor of approving the minutes from July, say aye.
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 Any opposed? All right, the minutes have been approved. All right, next on the agenda were our recent rules that we just published. It got brought to my attention, and then I did sort of a deep dive, that there were some pieces of the rules that OTAC had sort of voted on. There were pieces of the rules that we did not change, that OTAC did not touch, and they were included in the version that went to the board, and that they were included in the version that OTAC voted on. But in the end, some of those sections were not in the final published rules. And so I asked Patricia to sort of go over that with us. And anything you see in green are some areas that originally OTAC had thought were going to be in the rules, but they are not
No,
currently.
they still
So,
are. Lauren
yeah.
can explain it in greater
Oh.
detail.
Great, go ahead, Laura.
So with the rulemaking process, if you're not actually editing a rule, so it's like 1915 and 1917, y'all didn't make any changes, y'all didn't take anything out or do anything to those. So
Right.
those aren't reprinted in the notice of intent because those we're not noticing the public that we're intending to change those rules. So those are all still in the rules as they stand. They weren't just published in the register or anything because there were no edits made to those. So just because you don't see them in the NOI doesn't mean, or the final published rule, like that was published in the register, because there weren't any changes made. So they still exist in the administrative code unchanged, if that makes sense. So they're not deleted.
So if somebody goes to look at the rules, they will see all of those rules still there the way they were before we amended and added and changed other rules. And only the things that were changed were what was included in the notice of intent and was adopted and officially published in the register in June.
But I thought I looked at the rules that are on the website, and they didn't contain this.
What's on the website through the status of the rulemaking will have the final published notice of rulemaking. So maybe they just uploaded that instead of uploaded it from
If
the
you go to
administrative.
Westlaw and look up this section of the administrative code, these rules are still in there.
I guess I'm just thinking about like the average OT who wants to read a comprehensive list of all of the rules. When they click on the LSBMU website and click on rules, and what comes up does not include these sections.
So that must be just an uploading error on our part in that, well, like Lauren said, somebody just uploaded what was approved
register.
in the register as opposed to just inserting that into the, melding those two documents to post it on the website, on our
Yeah, we'll just
website.
make sure that if they have like the individual rule that the section from the administrative code is in there and not the one from the register.
Yeah,
Has
so
the
apparently
administrative code been
somebody,
updated?
What?
Has the administrative code been updated?
Yes.
Okay, we'll take it right from there and put it on the website.
yeah, it was just somebody, whoever uploaded it mistakenly thought that this was a substitute for the entirety of the rules as opposed to just having changed certain of the rules. That's just
Okay, well, that's
And-
good news. It sounds like that'll get is going to be taken care of.
Yeah, and then the other last thing that you had on there was the changing of the language from like the AOTA guidelines to best practices. That's because there's a rule when you're doing rulemaking for in the administrative code that if you are referencing a document that is outside of the code that already exists, you have to file that document and then you're basically standing that in amber of that version of the document. So I know that we had the conversation between the staff of the board. I thought we had it with y'all too, but maybe not. We had to change that on the recommendation from the register to word it as best practices or something like that. Because if AOTA made any changes, we would have to go back through this whole process and upload those and change those documents and notice it. And it doesn't allow the flexibility that was intended by allowing, those outside organizations to prescribe those best practices. So that's why we had to change that language, which is not a y'all specific issue. It was just something that we didn't, I guess, catch or talk about when we were in the process of drafting.
Okay, all right. I guess it's just as long as OTAC, when issues come up, if there's an issue of an OT practitioner who's not, who's got a practice issue or a practice question, that OTAC understands that when we put best practices into the rules, we meant AOTA documents. Or that the AOTA documents should be referred to.
Yeah, that's just not something that we can refer to in the administrative code.
Okay.
So that's just going to be something that, as OTEC is right now, or, if something else comes in later that AOTA isn't the best, one to prescribe the guidelines, that y'all decide on what's best y'all apply whatever is actually best.
Yeah, that's just going to have to be an institutional knowledge kind of thing that you pass on from one committee iteration to the next.
Okay. Any public comment?
No public comment at this time.
All right. We'll go on to our next agenda item, which was a question from an OT practitioner that was sent to me that I did feel like OTAC needed to talk about. as opposed to me just making an opinion, because it is a little bit interpretive. I'll get there in just a second. I know it's on here. There it is. Okay, so this occupational therapist says, hello, I'm looking for clarification on supervision after the May 2025 changes. The way it reads is that general supervision must occur monthly. Does this, and I assume, by the way, that she's talking about OT assistant supervision. Does this mean that the OTR does or does not have to treat the patient at least monthly? So I did look up our, I did look up our rules and I highlighted a couple of things. Let me reshare the screen. I have to find the right section. Hold on. 40. To me, there's kind of two pieces to this. One, of course, is the supervision rules with OT assistants. But the other is the intervention plan review and modification and the OT's responsibility to be involved in that. I'll just start with our supervision rules that we created. We say that general supervision is required for an OT assistant, and that means they need to meet monthly at minimum. And we have all these ways that they can meet. The OT could observe, they could model what they want done. It can be a co-treatment, it can be a discussion, it can be teaching, instruction, a phone conference, a video conference. And we did not specify the frequency. It has to be at least monthly, but it could be more often depending on the setting and the complexity of the client. And we leave the onus on the OT and the OTA to know when they need to meet more frequently. So we don't, in the supervision rules, specifically say that the occupational therapist has to treat the patient at least monthly. We're saying that the OT and the OTA has to meet to discuss the patient at least monthly. Are you guys interpreting that any other way other than what I see?
And the client care conference would explain more detail, right? That definition is in there.
Yeah, that's a great point. Let me go to the definitions. Let me see how I can get there.
I see her email, but is this it that she sent in, or is there anything else where she, where she references a part, she references a specific thing within one of our documents where she has where she's interpreting this?
Yeah,
I feel like it's probably because last time or the old rules said that they have to be treated, a certain amount every sixth visit, or I can't remember exactly how it was stated, but it was only in certain settings. So I feel like people that worked in those settings are really trying to make sure that, okay, we really don't have to do that anymore because it is a huge change for them.
yeah. So exactly. I think that's where it's probably coming from. And Glenn, no, all she did was send us one email. So the client care conference is a meeting between the supervising OT, who must have previously evaluated or treated the client. I'm glad you asked us to look at this, because in the question from the practitioner, if the evaluating therapist or if the therapist who's meeting with them has never actually treated or evaluated them, then they need to do that. Anyway, must have previously evaluated or treated the client and an OTA to discuss client progress or lack thereof, client issues, revision of goals, initiation, modification, termination of the program plan, assessment of utilization of additional resources, discharge and any other information, which may affect the client's plan of care. The minimum standard of frequency for this meeting is monthly for each individual client. This meeting can be conducted using a variety of types and methods as outlined in 4926.
So my interpretation of that would be if the treatment would only be required, or the OT would only have to treat if they had not already either evaluated or treated that client. So then they could co-treat together to solve that. Because then you would get the discussion, the observation, and that OT treating the client at that time to be able to discuss the progress.
Yeah. I'm just taking notes so that we can craft a response later.
Can we talk a little bit about the philosophical construct of drafting a response by this advisory committee to a request?
Okay.
I would really like Patricia to comment on it because, quite frankly, I don't give legal advice. Patricia, as an attorney, really doesn't give legal advice because the board does not give legal advice. And when you interpret the rules, that could be construed as legal advice, and I'm not sure you should do it, but let's see what Patricia says.
Yeah, it's a fine line. I mean, we do want to assist practitioners in navigating the rules to the best of our ability. If something is murky, or they don't know where to find the rule, or they don't know what rules apply, we certainly can assist them by directing them how to read the rules and figure out what the answer is. Telling them the answer is where the problem comes in, because most of these questions are all extremely fact specific, and it basically is their get out of jail free card. If we say, yes, do this, do that, or the rules say you do this, do that, so you're good to go, then we're stuck with that if something happens and they say, well, that's what the committee told me to do, or that's what the board told me to do. So the way we generally answer these things is to show them where the rules are and what rules apply to their question, which I think that's what you're doing here. You're gathering together that information, but it's always the letter, or the response usually says something to the effect of, well, we can't give you specific legal advice or tell you how to practice. These are the rules that should answer your question.
Yes, that's kind of how we've done this in the past.
Yes, yes.
Just same as what we've done in the past.
I mean,
Could
And
we,
also because these rules are new, I also just like OTAC to sort of also, we need to be very familiar with them, obviously, and understand what we wrote.
right.
Yeah,
I mean,
exactly. And
I
in
think
and it at some point, if you think the changes are if it's something that we should notify OTAC occupational therapy and OTA licensees, hey, newsflash, put it in the newsletter, put it in a blast email that says, here's an update on rules that have changed in the past year for your information or something. I mean, we could do that too if you think that would be helpful.
I mean, I see what you're saying, but I feel like as a practitioner and educator and trying to make sure that people are following rules and that they understand them. If we don't understand, I don't know how they are. If there's certain parts that we're confused about, and then they have to make a decision, and we say,
Oh, I agree with you totally. If y'all are confused about the rules, that's a whole other problem.
yeah,
That's a whole-
exactly. So I feel like, I mean, I don't know. I feel like we should be able to provide some kind of insight into the intent.
No, we can't talk about intent. Because if the rules meant to say green, that's what you meant, but they got published as red, we're stuck with red until we change them to green.
Glenn, you got your hand up?
yeah, I just, so I guess my thinking is like, as a practitioner, when these rules are open and we come together and we meet and we get to brainstorm how these things should be, to change the language, how these things should be written, like, you know, that's us coming together and providing our professional opinion on this matter. And then whenever we say it's closed, like I can understand how the practitioner could be somewhat frustrated when they say, they could have the attitude, well, you guys just talked about this and you created these rules. So why can you not give me an answer to the rules that you just created? I understand I understand that like I can understand what was just what was just said from the legal standpoint. But I guess if we're speaking philosophically or just, from another standpoint too, just logically, I would be like, I would understand how somebody could be frustrated, but where the same people who just took the time to reword things however they wanted to now can't provide an answer based on what they just came up with. That seems a little, that could come across as frustrating. I guess that's the point of view that I'm just inserting here. I'm not trying to criticize it. I'm just saying I could understand how this could be odd for somebody who's looking for a solution from people who created these things and then they can't provide one.
Yeah,
Well,
that makes
we've been able to
complete sense.
answer questions in the past by first talking about it amongst ourselves. I usually then draft something, send it to Patricia. She tells me whether this is sounds like we overstepped or versus we're just pointing out where they should find the information. And I mean I just want to do the same thing that we've done
Sure.
in the past.
Yeah, all of your Kelly's and Glenn's points are completely valid. I totally get that. And to me, that the distinction between if one of your students or one of your colleagues says, "Hey, I know you're on the committee. This I don't get this rule." You can have an anecdotal conversation. You can have an informal conversation that says, "Well, this rule is generally meant to do blah 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 blah." Give them some context if you want to do that. Where the lawyer part of me draws the line is when someone sends in a written request and wants a written answer, we have to be careful about the answer that we give. And if we did our jobs right, the rules should speak for themselves. If they don't, that is on us, not on the practitioner. I accept that 100%. So if we're recognizing, as Ingrid has brought up in the past, if we're recognizing that the same question keeps coming up over and over, that sounds like a drafting problem that we probably need to fix versus just helping somebody out who is just trying to get it in context and do the right thing.
Okay, good. Thank you. The other piece to me of this question is to point out to the practitioner this section, which just outlines the OT's responsibilities in terms of intervention plan review and modification. So I was kind of thinking of that the response would be to, that the OTAC does not state that the OT must treat the client at any certain number interval, or the rules, excuse me, the rules do not require that the OT treat the patient. But they need to review the definition of the client care conference. And they need to review this section about the intervention plan review and modification and their responsibilities towards that.
And I would always suggest, whenever I'm answering these sorts of emails, I always like make sure to put in at the end, like, and also we highly suggest you speak with a private attorney to discuss the specifics of your situation and how the laws and the rules apply. Like, start out by saying, we cannot give you legal advice, but we can point you to these rules that might help answer your question at this time, like, yada, yada. And then like bookend it on both sides with, you need to go. Like, we're not able to actually answer your question fully.
Is
Like, you should
are
discuss.
you I'm sorry.
I know, continue.
I was going to say, as a resource to practitioners in the state, like I could also see how that could be oh man, I have to talk to a lawyer now, and then that could be expensive. You know what I'm saying? Like, not that it's not ultimately worth it, but do we like LSBME or OTAC? Like, I know you're a lawyer on this call. Are you a potential resource that we could refer people who have like a question that needs to be elevated to that degree? Are you somebody that they could initially reach out to as a in-state OT based resource who is like on the front lines of this, or
Unfortunately
no?
not, because technically Patricia and I are the board and the agency's attorneys, not the public's attorneys. So that's why like we don't have that same client
Okay,
relationship and that we can give people advice. Like we give the board and the committees advice on the law. Like we don't have the ability, and the board doesn't have the ability to give legal advice to the public, which is
okay.
why when we do like advisory opinions, those advisory opinions go through like a lot of different steps and become official published, opinions of the board, but that are limited to the facts presented in the initial request. So like these little emails that go back and forth, since they have a much more, I guess, lesser level of formality, they allow for the, maybe creating many more issues, because if the initial email doesn't have all the facts in it and then we're giving an answer, they might misinterpret our answer to apply to facts that we didn't necessarily understand. Um, and so like it's just a lot murkier. So that's why like we just don't have the ability to give them legal advice that they can rely upon if they interpret it the wrong way. Does that make
No,
sense?
no, that does, and I think that's really helpful. And I think knowing that okay, just me personally knowing that that's really helpful, because then that also points toward the benefit of being an LOTA member on the other side of this,
Right.
because LOTA does try to have a lawyer on retainer, and if that lawyer is now familiar with these new rules, then that would be the person to direct these people to. Not
Yeah, I
you.
think if that's available to y'all, that's a great resource because they have that relationship that, they're open to
Right.
maybe giving you legal advice. We just don't. Like it's just not, they can't legally rely on it, because we're not their
No,
attorney.
And
no,
we're not really
that's good
telling
to know.
people, yeah, we're not meaning to tell an average OT that's just out there practicing in the wild, you got to go get a lawyer to figure this stuff out. Many times this is coming from someone who works in a facility or an institution, and there's usually legal counsel that works for their employer, if you will. And that's who we're really meaning. Like that's the people that are paid to give you legal advice versus us, and we're not. But
Right.
Patricia, the template that we've used in the past with answering questions has included the first part that you talked about. This is not legal advice. It cannot be construed as legal advice. We've never included that second piece that you were just referring to about if you need more advice, then you should get a lawyer. That piece feels a little scary. So if when I send you the draft, I mean, if everybody sort of agrees on what I just sort of said, that the response would include affirmation, confirmation to Samantha Harrison that, that there is nothing in the rules saying that they must treat the patient, but then referring them to make sure they have read the definition of client care conference, make sure they have read the section about intervention plan review and modification. If everyone's okay with me drafting that, then I'll send it to Patricia with that template language we've used in the past about not any legal advice.
yeah,
And then Patricia, if you really think we ought to add that piece
no,
about a lawyer, but that feels a little bit more over the
no, it's
top.
okay. Lauren's just talking about a template that we use when people send us public records requests or send us requests for advice under the guise of a public records request. So we answer their request by saying, hey, we can't give you legal advice, but here are the rules. if you need something more than just being pointed to the rules and how for your own interpretation, then, seek outside legal help. But we don't have to put that in this since it's fine.
Okay. Does anybody have any issues with what I kind of plan on drafting?
No, I think sounds perfect.
Okay.
I
All
did have
right.
one question. I did get one email that I wanted to bring up to y'all today that's kind of fitting into this, where we got a question of someone who was licensed in both states, I mean, in Texas and in Louisiana. And she was asking if she could get credit for the supervision of a level 2 Texas OTA for her Louisiana CEUs.
Yes. I
Yes.
think. Well, that's how I would interpret it. I should ask everybody else too.
I mean, I would think so because
I didn't see anything in the rules when I looked at it like quickly, and I'm not sure if licensing or if they answered this, but I didn't see anything where it said, it has to be in state. But I was also thinking, you're supervising someone in Texas who's operating under Texas rules. Like, is that still applicable to your CEUs in Louisiana?
I
Yeah,
would
but
think it needs to be because like I went to I went to OT the Shreveport OT program, and we were sent to one of the field works was us going to Longview, which is in Texas. And so I mean I know that was part of our education, but like before the field work, but still I mean there's people who do that, so I would assume that would I would think that we should be able to do that, or to say that that's okay.
yeah, fieldwork education is very standardized across the country. And so it's not there's not really a difference by states.
So that
Okay, perfect.
this assumes that all of these are people who are in training that are being supervised.
Correct. Yes, and we already have it built into the rules what the OT practitioner needs to provide in order to demonstrate proof that they supervised a student for the 12 weeks or the 8 weeks, depending on if it's OTA. That what they have to upload to CE Broker to prove that. Okay. Let's see. The next thing was the update on the tracking document. There, it was blank, but I guess I might add this question that we answered today to it. So, again, like it'll be there for in the future. And we can kind of keep up with what people are asking. Next on the agenda was asking Dr. Van about, well, let me change back to the agenda. Was getting an update from you, Dr. Van. Is there any news about changing the law in the OT law about temporary permitting, or is there any update on that?
That is in process. It has not been finalized. We are working with the writers of bills to make sure that we have the option to do it as a may, not a shall, and utilize it in the proper venues and settings and avoid the use of it as routine. But again, it is still in process and the bills are being drafted now.
Okay. And kind of on then the same line, there's a discrepancy between the law and the rule regarding waiver of continuing education. Let me just share the screen again with a different thing. Hold on. This is the law, and section 3012, letter B, number 3 of the law says the continuing education requirements shall not apply to individuals working as OTs in state facilities or employed by a state agency. we had that language in the rules and we took it out because we want all OTs to have to get their continuing ed, whether they work for the state or not. So I guess what I'm asking is when the law is quote opened in order to change the temp permitting from shall to may, could this thing that I just highlighted here also be removed so that OT practitioners, regardless of where they work, do have to fulfill their continuing ed requirements?
We certainly can and are happy to do that. To be clear, let's go over a few things. Let's say you have a OT that is working in only a federal institution. Let's say an OT that works at the VA and nowhere else in Louisiana. They are exempted. An OT that has been deployed in the military, even though they're licensed in Louisiana, they're not practicing in Louisiana during that time of deployment. They have a waiver of that so that they don't have to do the continuing education during the deployment. But we can, if we take that out, we can clarify in the rules to be sure what we want. But again, we routinely give the military deployed people and the federal, we do not get it. So for example, a Texas OT that works at the VA does not need a Louisiana license, and they do not need the Louisiana requirements. The Louisiana licensed OT that only works at the VA and does not work outside of the VA does not require it. But if that, and so Patricia may have a question about what I've said, or say it better than I do because she's always better at that.
No, you're absolutely correct. I just wanted to make the point that this is a provision or a suggestion that we will need to confer with LDH about, because this may be, this would impact state facilities, and there may be cost associations and so forth, or this is putting an extra requirement on state employees that is not currently in the law. So we would want to double check with them first to make sure that they would not be opposed to that. I don't see why anybody would be opposed to better education and more education and training, but I don't think we can promise that the board could make that recommendation without also just running it by LDH.
I hope they don't give us any trouble. There's really honestly no reason why an OT working for the state shouldn't also, I mean, I work for the state. I'm one of them. There's no reason that I shouldn't also be getting my continuing ed. The state's wouldn't even necessarily be required to pay for it, each individual OT. Most employers do support their OTs with some continuing education money, but not all do. So I hope they would understand that just because you work for a state agency doesn't mean you should not have to do your continuing ed each year. That's going to wind up with a lot of like OTs working for the state who might not be up to snuff, It
starts in 15 minutes.
The justification for it is 100% understood. I just wanted to throw that caveat out there that we will have to talk with them about it.
I'm not even happy to hear that the VA doesn't have to. But this particular piece
I didn't even think about that.
About the feds at all. It just talks about the state. So
yeah.
Well, again, we do not regulate federal employees in federal installations. We regulate the federal employee that decides to moonlight in Louisiana outside of the federal work that they do in the federal installation.
Well, we have to hope that the OTs at the VA are just undertaking continuing it because they want to.
Well, I can tell you that the VA
We
has
are.
rules about continuing ed.
There you go, Mary. Oh, I'm sorry, Dr. Vane, go ahead.
No, I was just going to say that the VA has their own rules, but about continuing education that are different from ours. And Glenn's got his hand up, and I want to make sure we get them addressed.
Glenn? Oh, you good, Glenn?
I'm sorry. If that's something that that currently exists, shouldn't there be something in the CE broker process that would allow you to like that we should be, allowing either practitioners or tracking, that this person is still allowed to be licensed in Louisiana, but they are a state employee, therefore they don't need to submit I I feel like this opens up a whole new can of worms where like how do you renew your license despite not needing these things to be a CE broker, which is needed, whenever you go to
They
renew
have,
your license?
they have to tell us that they're exempt, and then we tell CE broker they're exempt. If they don't tell us, we don't
Okay.
know. And so what happens is they either routinely send us the notification, or when it goes to apply and we can't renew, they call us up and say, I'm supposed to be exempt. Good, just send us a statement that you're exempt, and we put it in the C broker, and it's done. And then they can renew the next day.
Okay.
But if we don't, we don't necessarily track where you work. You have to tell us.
Right, right.
Okay, so it sounds like, Patricia, we might, are you saying that you, will follow up with LDH on this, or where?
Dr. Van will, and then
Okay.
and depending on the information that he gets, we'll let y'all know, and if we get the green light from them, we can include that in our bullet points for the legislation that we're trying to have someone sponsor for us. And if there's pushback, we'll come back and talk about it some more.
Okay,
But
great.
Dr. Van handles those high level communications.
Gotcha. All right, thank you, Dr. Van. All right, we're back to Dr. Van again, for our next item, which is about, any updates on the compact, Dr. Van?
Yes, we are trying to finalize our API with them, and once that's operational, we will start allowing. So the process is going to be as follows. If somebody wants to join the compact, once we get it up, we will send a notice that we're operational to all of the OT community. The OT and OTAs will all have a notice saying that we're now able to allow them to apply for a compact license in another state. At that point, we're going to tell them that they have to ask us, they want to initiate the compact process. We then send the information by API securely to the compact. The compact then sends us back, sends them the information that they need and what states they want. And then they continue with their license in Louisiana. Their license does not become a compact license in Louisiana. It becomes a compact permission in a state where they want to utilize it. That's for the outgoings. When it's operational, the incomings, the compact data people will send us an API request to grant a license / permission, because the law says that a permission is a license, and we will make sure that we have all the necessary requirements. The biggest difficulty remains the fact that not all of the states' OT licensing boards require criminal background checks. We will require criminal background checks because Louisiana has to have that, because it says anybody licensed to do healthcare in Louisiana in OT has to have a criminal background check. So we will make sure that they get the criminal background check if they haven't had it, and then we'll grant them the permission. So that's where it is. It is evolving. They've gone away from the original concept to just send us everybody's data, and so we're following the state regs now and securing getting that done. And we work with them on their rules, and they've been very tolerant of our needs in Louisiana, I will say, begrudgingly sometimes, but they understand we have to follow the law in Louisiana too.
All right, well, that's actually really good news. I mean, it sounds like it's finally moving forward in a direction that also protects the privacy of data of people who aren't interested in doing that.
Yes, that's why we did it that way.
Yeah, that's great. Cool. Any questions from anybody for Dr. Van about the compact? Okay. Any public comment? I forgot to ask that with the last thing.
We do not have any public comment at this time.
Okay. All right, well, we are up to I'd actually rather go ahead and do the vote for OTAC membership next, even though on the agenda it says to review the reinstatement of license after 2 years or more practice. I'm not sure that's that would just be really more for our own information for OTAC to sort of re-review what we wrote about that. So that we kind of, because that came up before and felt like we weren't all sure. Again, it's like another time where we just need to converse about what we wrote. But I would like to first do the ballot app, the vote for the OTAC members. And I think I have to scroll pretty far down to get to the ballot. So give me a minute. Here we go. Before we vote, we just have to agree on the ballot, or that's what I'm calling this. We have 4 positions, and so based on the people who were coming off, we had developmental disabilities, pediatrics, education, and physical disabilities, and assistive technology. So we did have 2 applicants who both work in developmental disabilities, John Silbernagel and Colin Hernandez. We do have 2 applicants who work in pediatrics, April Payton and Kimberly Bradley. For education, we definitely have one, Rebecca Wilder, who is faculty at LSU Shreveport. And then we had another applicant named Becky Swallow, who primarily works in physical disabilities. What was Becky's most of her job? She owns Full of Grace LLC. So she mostly works in physical disabilities, but she also teaches adjunct at Baylor University in Texas, specifically for their labs. So I think she goes there and she grades the students for their hands-on competency testings. So I wasn't sure where to put her. Personally, I kind of feel like she's more in the physical disabilities AT. It would mean that we only have 1 applicant for education who would get it by default. So, I mean, let me hear from other people. Where do anybody else have an opinion on where Becky should go for the vote?
Well, just to get, I think, a bit of history, the reason you all wanted people in the past who were in education, because you wanted to reflect the educational systems in Louisiana.
Yes.
And the people that teach and work in Louisiana, who teach and work are Louisiana students. But again, if you want to go outside of Louisiana, that's your choice. I don't think anybody will object, but understand that you then subject yourself to criticism because you're not recognizing the value of the educators that work in Louisiana.
I agree with you, but Kelly?
Is there another page?
In terms of the ballot?
Yes.
No, it's just the 4 positions and
I mean, okay,
10 names.
I'm seeing the applicants, 1, 2, 3, 4, 5, 6, 7.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10. There's 10.
Okay, I get the screen that I see is what is everybody else seeing?
What, am I not sharing the screen with the ballot?
I just see that it says
I
OTAC
just see
applicants.
7.
Do you see where it says position 1, position 2, position 3, position
Oh,
4?
now I do.
You're
Okay.
sharing your
Oh,
summary.
we didn't see that.
I'm sorry.
That's
I'm
okay.
sorry
I was
about
like,
that.
wait, I don't see these people you're talking
Okay,
about.
I
Okay,
had the wrong thing. There we go.
got it.
Okay. Well, I guess my opinion was that Becky Swallow should be in the physical disabilities, and Dr. Van just sort of agreed with that. Does anybody have any other opinion about that, of where Becky should go on the ballot?
I agree that she should go with disability.
Me too. This is Carolyn.
Okay.
Kelly has her hand up.
I think she forgot to take it. There we go.
Sorry.
Oh, okay.
All right, then I'm gonna go ahead and get started with position 1. Oh God, how did we do this last time? Not with a vote. I guess I'll go through each person who's on here and you'll tell me whether you want to vote for John or Colin. And Glenn will be recording that. Okay. I'm gonna go down the
Can you
list
give me a
that I have
second to
on here.
get can you give me a second to get ready to record? Like, how are we gonna, like, because I need to know how you're gonna, because that makes it real hard to do it so quickly in the moment. Like, how do you plan on doing this going?
So I
Like,
was gonna call Carolyn first and ask her for position 1. Does she want
right.
John Silbernagel or Colin Hernandez?
Can you give me tell me the names of the people who you're gonna ask in what order, and then that'll make it easy for me to document as you go.
Carolyn, and then Amy, Mary, you, me, Ingrid, Kathleen, Raylena, and then Kelly.
All right, give me 1 second, and then I'll be ready. Okay, I'm ready.
Okay, so we're gonna start with position 1. Carolyn, are you voting for John Silbernagel or Colin Hernandez?
John.
All right. Amy,
John.
Mary,
John.
Glenn,
John,
myself, actually Colin, Kathleen,
Colin.
Raylena,
Colin.
and Kelly. Kelly, how about you? We need a tiebreaker.
I'm so sorry. I wasn't needed. I said Colin.
Colin? No, that's not actually a tiebreaker, is it? Or is it?
no, it's
No,
4 and
it is.
4.
It's tied. Oh my gosh.
Oh, no.
Well, simply we can say that the advisory committee recommends to the board these 2 names and they'll pick it.
Okay,
Okay,
sounds good.
they're both good. All right, we're moving on to position 2. Pediatrics. Carolyn, are you voting for April Payton or Kimberly Bradley?
Kimberly.
Amy,
Kimberly.
Mary,
April.
Glenn,
April,
I'm next. I'm also April. Kathleen,
Kimberly.
Raylena,
Kimberly.
and Kelly.
April. Did I just do it again?
This is crazy. Y'all. They'll both be good too. So we're lucky, I think. I mean, I don't know April personally, but her letter was great. So oh my gosh. All right. Well, and for position 3, we have only Rebecca Wilder. So I think she is winning by default. Patricia, should I go through a roll call vote on that anyway?
No, I mean, she's the only one that applied and unless 5 of you would object to her name being presented to the board, you'd fine to go on.
Does anybody object to Rebecca Wilder's name being presented to the board?
No.
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 All right. And now we're moving on to position 4, physical disabilities and assistive technology. So Carolyn, are you voting for Savannah Alford, Amber Lupo, Becky Swallow, Christopher Di Benedetto, or Whitney Roden?
Whitney.
Amy,
I'm gonna go with Christopher.
Mary,
Savannah.
Glenn?
Whitney,
Okay, I'm next, also Whitney. Kathleen,
Whitney.
Raylena,
Savannah.
and Kelly.
Whitney.
Okay, we actually finally have one with a clear majority, a Whitney Roden. And I guess for the developmental disabilities and the pediatrics, we'll be giving both names to the board as recommendations and for them to pick one.
One question. I did not see that document on my copy of the that you're showing on the screen on my copy of the agenda. Can you send that to me so I can have it for the agenda?
Yeah, it is. I am sharing the screen with the cloud version, but yes, I'll
Well,
send
see,
it.
I shared mine from the cloud version too, and I can't find it. I'm sorry to be so dumb.
Huh. Yes, I will definitely send it to you. Very good. Now, let's see.
It's on page 32.
Got it. Thank you very much. Appreciate
Okay.
that.
Thank you, Carolyn.
You're welcome.
Okay, the last thing I guess I wanted to do was really just sort of go over the things that we have in the rules related to people who are trying to reinstate their license after they've been 2 years or more without being licensed in Louisiana or anywhere else. And I did do some highlighting on that too. Let's hope. Nope, that is not the right thing. I'm not sharing the right thing. Give me a second. I wonder if I didn't open it.
Ingrid, I have a quick question.
Yes.
Before we give those names to the board, do we want to look and see about city-wise of what we have and what we're fulfilling?
Oh,
So that by the state, does it make sense? Should one, and maybe we revote with, does it make sense? We also trying to get staying throughout the state, or does it not? And we go with the best candidate and not? That just popped in my head and I didn't know if we should address that.
You are 100% correct. I even wrote the areas of the people that were coming off. We've got one from Shreveport, one from Lake Charles, and 2 from New Orleans. So we know we've got Rebecca Wilder that we're recommending, and she's from Shreveport. We know we've got Whitney Roden we're recommending, and she's from Bossier City. So we would want somebody from the New Orleans area, I think, then, right? And somebody from Southwest Louisiana, preferably. Which would potentially be John Silbernagle, April Payton. Kimberly's also from the New Orleans area. And Colin Hernandez is from Santa Mont. Oh, this doesn't help. Isn't Santa Mont in but he works in Baton Rouge. Both of them work in Baton Rouge.
So it may be a mute point, but I just thought we
Yeah.
should bring that up.
Unfortunately, it feels like it's sort of it's another tie. You know what I mean? I mean,
Right.
because we could say, well, we should do John because he's from New Orleans, and April because then she would be Southwest. But you could just as well say, well, Colin's Southwest and then Kimberly's New Orleans.
Yeah, I think we can just remind the board that the geographic aspect is an element of some of it, and if the two that they have to decide, if that factors in, they can consider that when they break the tie.
Okay. Wow, that's something. Okay. Give me just a second about the number reinstatement. Here we go. I found what I'm looking for. And now I'll share the screen with that. And let me see what sections, page 657. Okay. So again, this isn't really in response to any kind of a current question. I just felt like we had a conversation and we weren't sure what we had. So this section is what we wrote about reinstatement, that an application for reinstatement has to be made in a format prescribed by the board with appropriate proof of continuing ed, late renewal and reinstatement fees as prescribed. Reinstatement of a license that has expired for 2 years or more may include additional fees and requirements as the board deems appropriate, including but not limited to re-examination. And this means NBCOT, in accordance with subchapter D. Satisfaction of the requirements of subchapter H with respect to continuing ed, and complying with all requirements and procedures for obtaining an original license, like a criminal background check. And then there was one more section. Well, subchapter A, page 659. So the failure to satisfy continuing professional ed section. The license of an OT whose license has not been renewed within 60 days after their license expired may be reinstated. So essentially, reinstatement is required if you've not renewed within 60 days. And of course, also reinstatement is required if you're not licensed at all. You used to be licensed and now you're not. So reinstatement may require a criminal background check at the discretion of the board. The applicant must also provide documentation and certification that they have, within the preceding 12 months, completed 14 hours of qualifying professional education, and that the applicant is currently certified by the NBCOT, as demonstrated by a current NBCOT certificate. So that was something we added with the rules changes. So it means that for people who've been out, in order to most easily get back in, they really need to be currently certified by the NBCOT. And of course, to be currently certified by the NBCOT, you have to have kept up with your CEUs and you have to reapply with them every 3 years. We don't say what we're going to do if they don't have the NBCOT certification. And this previous section didn't really outline it much either. It just said in a manner prescribed by the board. So I guess each thing we'll see as things come up with people who need reinstatement, people who've been out of practice for more than 2 years. But there's not really anything other than the fact that we're saying they need to be certified by NBCOT. We don't have anything else that we are outlined about what they would do. I guess they would need to go to NBCOT and see about getting certified by them if they weren't. So that's all I wanted to sort of, I guess, remind everybody about. All right, so really I don't have anything else. Any public comment? Excuse me.
No, ma'am, you have no public comments at this time.
Okay. Our next meeting will take place on Friday, November 14th, 2025 at 10 a.m. And this meeting is adjourned at 11:12 a.m. Thank y'all very much and
Bye,
have a good
Louise.
weekend.
Thank you.
Bye.
Thanks, everybody.
Bye.
Appreciate all the time you devote to this.